Our viewers had questions, and we have some answers regarding the grant of rights, sovereign immunity, and fiduciary responsibility.
College football expansion and realignment is always in the news, so we're back on the big mountain to break it down for you.
Hey, it's good to have you here on the mountain. If you're new to the mountain, I am JY. This is my good friend Steve. We have jumped into this ACC FSU lawsuit issue that's been going on. This will be our, I think, third episode specifically on the lawsuit. But you've been following, obviously, some of the FSU, ACC, Big Ten kind of ongoings here for a while now. So if you're interested in any of that, you can check out our channel. But I want to get into a little bit more with the lawsuits. Our last one, we had a lot of good comments. I want to try to answer some of those comments, or at least have a discussion on some of those comments. A lot of people were really interested in how we broke down, I think, the penalties and what numbers, how those numbers came up with. I'm going to end with that because I have a bit of a question on how some of these things are worded. And you can tell me I'm out to lunch, or maybe there's something there, but I'm going to save that for the last. The first thing I want to talk about, I want to give just a brief history lesson using Maryland as kind of our case study here, because that just happened only about a decade ago, a little over a decade ago. And does it give us a little bit of a roadmap as to where things may be headed? So on September 12th, 2012, the ACC amended its constitution to create this more severe penalty. We talked about that and how that's calculated. It's 3 times the annual operating revenue. There was a question of who approves the ACC operating budget. I don't know this to be fact, but I would assume that it's the trustees, it's the members of the ACC that approve the operating budget of the ACC every year. That's pretty much how all of these types of organizations run. Right. They're presented with a budget, they can discuss it, they can approve it or deny it. So I'm sure that's what happens with the ACC. In November 19th, 2012, Maryland withdrew from the ACC. I found it interesting, and I don't know if you knew this or not, but Maryland actually opposed the penalty. They opposed the increase to the penalty, and they actually voted against that ACC constitution when it was done back in September of 2012.
Yeah, and at the time they were basically looking to leave. They were
right.
They were hoping to get that invite from the Big Ten. So
clearly that was 2 months prior,
yes.
So they knew what was going on, and of course they're going to vote against it because it means that they're going to pay more money. 1 week after they withdrew, the ACC sued Maryland in North Carolina. Same type of deal we have here. The ACC is suing FSU in North Carolina. Maryland countersued the ACC in January of 2013. So it took a little bit longer for Maryland to countersue, but we have the same type of situation here. Timeline's not quite the same, but it's close. In June of 2013, a judge dismissed a portion of the case and ruled that the rest of the case, this is Maryland's case against the ACC, the rest of the case will have a stay pending the North Carolina case. So Maryland obviously filed in Maryland, just like FSU's filing in Florida. In June of 2013, he dismissed part of Maryland's case and he put a stay on the rest of Maryland's case and kind of kicked it back to the original lawsuit, which was the ACC lawsuit in North Carolina, which is what's happening here. Yes, it was only a day later, but the ACC got it in first. Whether or not that's important or not, I don't really know, but that is what happened. What ended up happening then, the severe withdrawal penalty at the time for Maryland would have been $52,266,000 and some odd dollars. So $52 million was this new severe penalty for Maryland. In August of 2014, the two sides agreed to a settlement, which is obviously where we think this will probably head eventually, but the two sides agreed to a settlement of $31.3 million, so about 60%, almost exactly, 60% of what that severe penalty would have been, but greater than the previous penalty, prior to that September 12th vote, which would have been $21.7 million. So in between kind of what the previous penalty would have been and this more severe penalty.
Split the difference.
Yeah, for the most part. Now, how exactly did they come up with it? Lord knows. We'll never know. I don't know if it really matters. But we'd had another question. It's like, how long could this all take? It really depends. Some of it depends on the courts. Some of it depends on if there's a settlement and how long it takes to get to a settlement. In this Maryland case, it took about 22 months from when they first filed lawsuits until they had an agreed upon settlement. So if that gives us any indication, we're looking at maybe 2 years on this. I mean, again, it depends on how quick the courts are going to move and some of the answers from the courts. We saw that's kind of how it worked in the PAC situation as well. Yep, go ahead.
Yeah, so we've thrown this Maryland example out a couple times when we talked about the ACC. Mm-hmm. I think we even used it as an early example when we were talking about the PAC.
Yes.
And how, just kind of as a general example, because Maryland, that was like really the first one in the era of big money, and how, you had an agreement, you had suits and countersuits, and then you have a settlement somewhere in between. So we kind of use that as precedent. Now, it's hard to tell, how does Maryland law differ from Florida law?
Right.
We don't know. We're not lawyers. It's something we can look into in the future, so we don't know. But I think it is just a starting point, just to kind of give you, okay, this happened before. This is the timelines. This is the mechanics they went through.
Exactly. I mean, certainly going to be some differences, but I thought it was good. Hey, let's go back and just remember how that worked, because things are somewhat similar to how things are going right now. Again, timeline not exactly the same. So I wanted to get into a little bit more detail on the original 2013 grant of rights and the amendment to the grant of rights, and whether or not they actually got the 2/3 vote. So I'm going to answer that question, but then I'm going to put a but behind it. So yes, they did receive the 2/3 or more vote for the 2013 grant of rights. Yes, they did receive the 2/3 or more votes, and it's documented in the ACC filing in 2016. So yes, both of those were approved, but I want to talk a little bit more about the 2016 amendment. Did the amendment talk about the extension to ESPN and giving them that extra time from 2021 to 2027? So here's the answer that I could find, and I've looked at all of these documents. The 2016 amendment that was sent to the members only detailed the term amendment stating the term of this agreement shall begin on the effective date and shall continue through June 30, 2036. That was pretty much the only thing that was laid out in that amendment. It was just over 1 page document that was sent to the parties. So was this ESPN extension part of that? No, it wasn't. Was it part of the actual grant of rights amendment? Yes, it was. So that's where there's going to be this, well, these things are held under lock and key. We didn't see them. We went on this 1 page or just over 1 page document you sent us, to which, yes, we approved. But the only real item on there of any sort of informational purposes was the extension through 2036. It did not talk about giving the option extension from 21 to 27.
Chime in real quick.
Yes.
Great points, and I want to add some context to that. So part of what Florida State is alleging is, I think it's the 2016 one, that there was, and I think you're going to get to this a little bit when we talk about fiduciary duty.
Okay, yep.
But that there was some coercion at the time. Yep. Everybody wanted the ACC network. They were given 1 page to sign, and basically the ACC, the conference, the representatives, the people who were negotiating with ESPN, basically told the teams, you got to sign this today or ESPN is going to walk and we don't get the ACC network. We don't get this ACC network. We're going to be, we're dead in the water. And so I think that coercion is going to feed more into what you're going to talk about later, which is the fiduciary duties.
Yeah. So let me talk a little bit more about that. And then, yes, we'll get into the fiduciary. But when the ACC network was launched in 2019, that is what then triggered the requirement for ESPN to exercise a 9-year option by 2021. So the triggering of that option and kind of the timeline for them to either accept it or not was triggered by the launch of the ACC network. However, in 2021, ACC Commissioner Phillips extended this option deadline until 2025. We talked about that. Commissioner Phillips sent an email, according to the records, 1 day prior to signing this, saying this added time could potentially prove beneficial if we're able to work out a different arrangement with ESPN. So the documents say that Phillips did send an email 1 day prior to him signing this option extension, but that it was at least communicated to the members. Now, I'm not going to sit here and argue that 1 day was enough or not enough, and if they should have known before or not before. That's what's in the lawsuit. That's what they're saying was known at the time.
And I think, correct me if I'm wrong, FSU is saying that he didn't have the power to do that. That it should have been voted on, not just notified, hey, tomorrow I'm doing this. It should have been voted by a majority of the board, and that was not that didn't happen. That's what they allege.
Correct. That's what they allege. Absolutely. Good point. Yes. So let's talk. I want to talk a little bit about sovereign immunity because we kind of had some questions on that. I did do a little bit of digging on that, and then we're going to get to the fiduciary responsibility. So Florida Statutes 1001.72 says that each board of trustees, and this 1001.72 is about universities. It's specific to universities. So here's what it says. Each board of trustees shall be a public body that has the power to contract and be contracted with, sue and be sued, to plead and to impleaded in all courts of law. The sovereign immunity, just as a broad term, it's a principle under which a government cannot be sued without its consent. Now, the question that I have is, this says that they waived their consent, or they waived their sovereign immunity. That's what the ACC alleges. So from what I'm gathering here, I think, and again, we didn't have anybody kind of chime in, and I don't know if they know the answers, but it seems to me right now that FSU could, and all of the schools, at least according to, I should say, at least Florida statutes, can waive their sovereign immunity to these contracts. And ACC saying that they did that. They signed off on that. So I think that is legally substantiated. I think that can be done.
I think that's something we will have to dig deeper in, because I think separate from this, I think there is another Florida law that basically says all of these public entities that, yes, they can go into a contract or whatever, but if there's any judgments held against them, that the state legislature basically has to approve that. So that's basically negating some of their powers to go into it. So
gotcha. Okay.
Great finding that statute. I think it's definitely something that we should dig further into.
Yep.
In the future, which is great.
Yeah. I mean, this is going to keep going for sure. So let's talk fiduciary responsibility. I want to talk about what FSU is specifically stating, because we kind of glossed over this a little bit in the beginning, and so I want to dig into it a little bit more. FSU states that the ACC owed its members several fiduciary duties. They specifically say, 1, securing, protecting, exploiting the athletic media rights entrusted to it, and 2, failing to protect and preserve the position of its undefeated football champion, aka FSU this year.
Right.
The ACC breached those duties for failing to negotiate and maintain market competitive media rights agreements. This breach was harmed, if not permanently impaired, the athletic programs of FSU and squandered and diluted the media rights and reputations of FSU athletic programs. So what is fiduciary responsibility? So I'm going to lay out, again, very high level, very broad, but what is it? The primary duties of fiduciary responsibility are one's care and loyalty. Also, there has to be good faith and confidentiality. Both the ACC and the trustees have these responsibilities. The one that I'm going to kind of poke a little finger at here a little bit is the duty of disclosure. And I think that's the ones that I just mentioned, I would say, I don't know if there's any issue with that necessarily. Now, FSU probably would say there's issue with that, but I'm not sure there really is. But what about duty of disclosure? So it gets back to what we talked about with this option and all this kind of stuff. The duty of disclosure requires actions in complete candor and to disclose all of the facts and circumstances relevant to making the decision. So hitting the nail on the head about what you talked about before when we were talking about this ESPN opt-out and other things. But, for this video, we talked about that one as being one. Well, we didn't know that. We weren't told that. Whether or not it needs a 2/3 vote, I'm not really sure. But at the very least, you would question whether or not there was a duty of disclosure here by the ACC and specifically the commissioner if those things were going on in the background. To me, this can be a very gray area. A lot of these things that I said, was there care, was there loyalty, were they doing it in good faith, was there confidentiality? There's gray there. But this duty of disclosure to me is kind of interesting. I think there could be something there. So anything you got?
I want to chime in there. And so that, to me, I think the fiduciary responsibilities, I think, is going to be the stickiest wicket for both sides.
Yes.
Okay. And I think that area is what's going to lead to an eventual settlement. Because here's the thing: if Florida State is alleging that the ACC basically coerced them into signing this because they wanted to keep Florida State, they want to keep everybody together, get the ACC, and they're telling, hey, you just got to sign it right now, or we're going to lose the ACC network, we're going to lose ESPN.
Right.
So if they're alleging that, which that's basically the gist of their lawsuit.
Correct. Right.
So what's the next step in that? If you go down the road, let's talk about discovery, which is before we even really get into a trial phase. What would they ask for in discovery? They're going to ask for emails, records of communications between the ACC office and ESPN, and between the ACC offices and Florida State and all the other schools.
Right.
And if there's anything in there that looks like that anybody from the ACC was misrepresenting what ESPN was telling them to any of the schools, that could be ball game.
Oh yeah.
Which puts them at a great risk. That's a big. I think there's people that focus on different things, and we did a breakdown of the years and all of that. But what really puts fear in people is discovery.
Right.
When you have to open up your emails and messages and communications from 10 years ago, which some of these people aren't even there. We're talking about Commissioner Phillips. He just started, in 2020 or 2021?
21, I believe, yes.
So 21. A lot of these things happened before he even got there, but he has been there since they extended the thing. So I think really that fiduciary responsibility, I think we will continue. My guess is we will continue to look at that area and go down that road, because I think that has a lot of traps for all sides, all parties involved.
Good point. The last thing I want to talk about is this grant of rights withdrawal penalty. So I was reading this, and I have read this 10 times. And I think I'm adding a word that maybe shouldn't be added. But I'm going to go over this here real quick, and you can tell me what you think. So the grant of rights, as we've said, is held under lock and key at the ACC headquarters. It's not something that's within these documents. We can't view it, and very few people can, apparently. I kind of question who has really seen it. I think all the members and according to some of these filings, the members have seen it.
Yeah, we've seen reports that they've sent all the schools have sent their lawyers to the headquarters to view it.
So they clearly have all seen it. But I do want to talk about the ACC's case regarding the penalties. This is paragraph 51, if anybody's following along here, Steve. And I'm going to read this verbatim. The ACC grant of rights purported to require, I'm sorry, not the ACC's case. This is from the FSU's case, from FSU's case. The ACC grant of rights purported to require that any member daring to withdraw would forfeit to the ACC all of its future media rights for the next 14 years through June of 27. Regardless of whether such member institution remains a member of the conference during the entirety of the term for which the ACC would pay the departing member nothing. The ACC grant of rights did not amend the constitution of the ACC, and then it goes on. And I just got to say, I'll bet you the Pac-12 wishes they had some of this language in some of their bylaws. But so I sit back and I say, okay, this says that it would require that any member daring to withdraw would forfeit to the ACC all of its future media rights for the next 14 years. Or if you go through 36, it's even more than that. But I'm going to focus on this. I question, are they talking media, the actual media rights, actually broadcasting the games, or are they talking about media rights revenue? And so that's where I get confused. Revenue's not in that sentence, right? But I've read it many, many times, and I add revenue into that because we're talking about the media rights revenue. Now, revenue, again, is not in that sentence. So let me lay this out. If it was revenue, if we're talking about the media rights revenue, if it's the revenue, then, and if FSU issues a notice of withdrawal on June 30th of 2024 for a withdrawal from the conference on June 30th of 25, they meet the deadline of August, whatever the heck it is, right? So we're withdrawing, they're notifying everybody in 24, but they're not going to actually leave for another year. So they're sticking around like the departing 10 did with the PAC, right? They notified, or some of them even more than a year, but I won't go down that rabbit hole. To me, that means they would not receive the media revenue for 24-25 because, hey, we're notifying you, and according to that paragraph, we're notifying you, but we're sticking around. That paragraph says, nope, you don't get that revenue, but we're going to still broadcast your games because you're part of the ACC, but you're not getting any of this revenue because you forfeited that revenue. Now, what FSU is doing is saying, this lost revenue is not only forfeited, but actually owed to the ACC for any leaving member in order to buy out, basically. Now, they don't say this, but I'm putting this in my terms. Buy out their media rights. And that's where they're coming up with that $429 million, which is the vast majority of the $572 million. Because they want to buy out their media rights so that they can then take their media rights off to wherever the heck they're going to go. The SEC, the Big 12, whatever it is. So, I question, does the grant of rights guarantee the ACC the broadcast rights of all the home team's games? That's my question, Steve. Like the first time I read that, I'm going, well, they're just forfeiting the revenues. And then I read it more and I went, no, are they actually forfeiting the broadcasting rights? Meaning the revenues don't matter. You're not going to get it anyway. Right. And we're still going to broadcast your games for the next 12 years. Right. And there ain't nothing you can do about it. I find that hard to believe, but maybe that is what it's saying. Help me.
I'm going to give you two answers.
Good.
First is I'm going to give you a short answer and a long answer.
Okay.
First answer is nobody freaking knows.
Okay.
All right, that's the short answer.
Okay.
And here's the long answer. The beginning of the long answer is, so I said the fiduciary responsibility, that's the sticky wicket. That's where the lawyers are really going to dig in, and, we're going to be looking at emails, we're going to be looking at, conversations back and forth, notes, transactions, all kinds of stuff. That's the sticky wicket. If that's the sticky wicket, the grant of rights is a big bowling ball filled with gunpowder, like in the old cartoons with the wick that's going down, and you're trying to blow it out because it's going to explode in your face. Yeah. That's the big ball of wax. That's the big kaboom. And that's what kind of people have been fighting over. And, and that's where you see basically that Florida State's trying to lay out the worst case scenario of how that could be interpreted and how that could have possibly affect them. Yeah. So you have some people that take the approach of, when they read this, that just means, like you said, they have to, if they're going to leave, they have to buy out their rights. Hey, this is this is how much we have to pay, which you would have gotten as part of the media rights deal if you were still here. You have to pay that out if you want to go somewhere else. But then there are a lot of other people who think basically what that means is exactly what you said. So for the next 12 years, Florida State will not have the rights, if they leave, to any of their home games, because you only have the right to your home games. Right. So, basically the ACC could just say, no, we're still going to own them. We're not going to accept any payment. We're still going to own them. So if you go to the Big Ten and Ohio State is visiting and Michigan and whatever, we're going to own those rights, and we're going to be able to sell those to ESPN. There's two different interpretations, and I don't know where it's going to go on that. Okay,
if I can just say, I don't know why anybody would ever agree to the second piece, the second option you gave there, which I understand how it can be read that way. Yes. I don't know why anybody in any earth would agree to something like that.
So, and that gets back to in their original Florida State's or the lawsuit, where they and also some statements from the Board of Trustees when they authorized that lawsuit as their justification for authorizing their lawyers, their solicitors to file the lawsuit is what they're saying is the penalties and everything that is in these bylaws that were negotiated. Yes. There's a question of what teams or what programs approved them, were they coerced, whatever. Sure. But whether they were coerced or not, Florida State is also alleging that the penalties are just so severe, they're just ridiculous that it's like basically if I came up wrote a contract with you and said, hey, we're going to flip a coin. If it's heads, you have to give me $100. If it's tails, then I have to give you every dime that I earn for the next 20 years, no matter if I earn $1 million or whatever. It's just such an unequal contract that it's not enforceable because it's so ridiculous. And that's what Florida State is alleging in their lawsuit. It's just some of the stuff in there is just so ridiculous that it should have never been in there. Yeah. So they're kind of going two different ways. They're taking a multiple prong approach. Yeah. And if this is where the lawyers are really going to get deep in the weeds of text and communications, that other one is going to be more open to interpretation and philosophy, and we'll see what judge reads it. We talked about that in the Pac-12.
Yeah.
You had a certain interpretation of when they give notification to leave.
Right.
And so you have one camp that said it's got to be a written notification. Here's a paper saying we determined to leave. Whereas the Judge Levy said, no, it doesn't. If you tell the whole world you're leaving, that's your notification you're leaving.
Yeah.
And that was his interpretation.
Yep.
And so we'll see what judge we get in this case and what their interpretation is.
That's a great point, and it'll end our episode, but lead us into what our next episode's going to be on, and it's going to be on just that. What is the specific language of withdrawal, and what are the punishments that FSU is looking for? I should say punishments, the counts that FSU is looking for, and when does withdrawal actually take place? So I'm going to give you a little teaser on that. We're going to talk about that in the next episode. It'll be shorter than this one. Got a little long-winded a couple times here, but hey, with that, we are going to keep on this. We hope you like us. We hope you subscribe. We'll see you next time on the Big Mountain.